could I ask for a motion to open the regular meeting of the Southampton Village Planning Board?
I'll make that motion to start the meeting.
Can I have a second?
I'll second it.
All in favor?
Aye.
Welcome to the Monday, June 2nd, Southampton Village Planning Board public hearing. If everybody could silence their cell phones, just so these deliberations aren't interrupted. And we had some notice today, a late notice today from David Gilmartin that he couldn't attend the meeting. So 2 of the applications which he's involved with, PEP2 Holdings and the Pelosi Ioto Enroller applications, he's requested those be
And
adjourned.
this one as well.
And GWB Southampton. So if anybody's here to hear what's going on about those applications, we won't be discussing them this evening. Unless, would you like to make a comment? Because actually the applications are closed, just waiting for his.
I'm here to be present,
Right.
with your decision about the Pelosi laundry, and this is it.
So nothing's going to happen this evening.
Today, nothing's going to happen.
Right.
Okay, thank you very
Sorry
much.
to waste your time.
Yes, thank you.
They're gonna go on to July 7th? July 7th? Dave,
That's when they're going to be adjourned to.
okay.
Why don't you make 2 separate motions right now, Roy, then to adjourn? One motion to adjourn to one and one motion to adjourn. I think
There's 3,
Ted
I
has
think.
actually 3, too, so you need 3 motions.
Well, actually, there's 3 here, and PEP has 2.
Pepper's-
There's another one, there's a GWB, Southampton.
What is that? I don't know what is that?
That's.
Is that even on the agenda, though?
I don't know if it's on the agenda,
It's not
but
on the agenda.
Doesn't look
Oh,
like
okay.
it's here.
he says they're waiting for a decision from the ZBA.
Not on the
Not even on
agenda.
the
Oh,
agenda.
okay, all right.
So then 3 motions.
This is the first.
How about this one?
I will make a
206.
motion at the request of the applicant to adjourn, for all purposes, the matter of PEP2 Holdings LLC until the
July 7th.
July 7th meeting.
For the
I'll sec-
subdivision?
That is PEP2.
Subdivision.
Yes.
PEP2 subdivision.
Right.
Is it the first?
Planning Board
Second.
2042. All in favor?
Aye.
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 I'll make a motion at the request of the applicant of IoT.
To approve the request of the
To
applicant.
approve the request of the applicant to adjourn to the July 7th meeting, the application of Ioto Roller and Pelosi.
I'll second that.
All in favor?
Aye.
You have to make a, Steve, you need to make a request for the site plan application of
Okay, and then I will make make a motion to adjourn for all purposes at the request of the applicant, or to approve the request of the applicant to adjourn the PEP2 Holdings site plan application until the July 7th meeting.
I'll second that.
All in favor?
Aye.
Aye.
2066, is that Dave too? Steve? 2066?
It's 2042, 2052, no, 2021.
No, I mean, he
Yeah.
hasn't sent us a note on it.
I thought Dave was the one that was on that. If he's the attorney, then he won't be here.
He hasn't sent us a note on that one.
Okay.
Okay. So the first item that we will talk about on the agenda is the Cowles Associates 477 Little Plains Road application.
Did you do this one?
Did not do that.
That's Dave also.
Maybe he sent somebody here for that.
Sorry,
Okay.
there actually is this other GWB is on the last page,
Yeah.
the 2058. So I will make a motion to approve the request of the applicant to adjourn the matter of GWB Southampton, 132 McGee Street, for all purposes to the July 7th meeting.
That's on the agenda as Moses Bishop as the last item.
Exactly.
And I'll second that.
All in favor?
Aye.
Aye.
Okay. Okay, now that we've done that housekeeping, the Cowles Associates 477 Little Plains Road. What is the status of that?
The proposed action involves a 2-lot subdivision of a 4.093 acre parcel zoned R120 in order to construct 1 new family dwelling. An existing single-family dwelling will be retained. It had received a zoning board grant for area and side yard variances. We completed the secret review and opportunity for public comment.
This is a public hearing, Roy.
Yes.
So you need to announce that it is a public hearing.
So this is the public hearing for that application. Is anybody in the audience here to,
Well, let's, right here for first.
Oh, Bailey Larkin with Bennett and Reed, here on behalf of the applicant. I have the affidavits of posting and mailing to submit. I don't know who gets them. In this application, the applicants are requesting approval to subdivide the subject property into 2 separate lots. In December 2013, the Board of Appeals granted a resolution approving lot area variances to permit the proposed subdivision, subject to the approval of the planning board. And also subject to the condition that an existing swimming pool and patio that's located over the lot line be relocated or removed once the second lot is sold off. When the property was first acquired by the owner, the 2 lots that we're proposing were considered conforming lots. After he owned the property was rezoned to R120, increasing the lot size requirement. This property is already designated as 2 separate Suffolk County tax map lots, so the proposed subdivision will occur on that tax map lot line, and it'll create 2 lots that are consistent in size with adjoining parcels in the area. So
Great, thanks.
basically it.
is there any public comment?
I'm here representing the neighbor, and his comment is,
Could you come up forward and speak into the microphone so everybody at home can hear your remarks?
I'm representing Bruce and Avis Richards. They sort of object to it. They're not too happy about it, and they said if they could do it, then they're going to do it also on their lot.
Sir, could you provide your name for us?
Carl Giafurta,
Spell that, please.
Giufurta.
Do you have anything in writing from, do you represent, are you legal counsel to the,
I just work for them.
just work for them?
So if you need legal counsel, then we'll get to
Well,
that.
we'd like you to document your status for them since they've not appeared here tonight or otherwise previously communicated with the board that they object to this.
Okay,
But that's okay, we can deal with that in the future, thank you.
okay.
And what are the grounds for their objection?
Legally or just, I think it's their concern for the neighborhood, the condition of what's going on in the area. And how it affects the view, how it affects other people looking over into their property. Because,
So this was just a generalized objection?
yes,
Okay.
And if it's okay, they would like to know if they could do the same thing,
Mm-hmm.
because they have about 5 acres on the corner.
Well, you either object or you don't.
So, yeah, that's it. That's all I'm saying. If it's, I don't even know if it's I was
This
told.
isn't the board of revenge, this is the board.
This is the board, the thing is they could legally do it, but the opinion is what I just said.
If they have the facts and the circumstances and
That's it,
whatever
yeah,
else
so-
to comply with the zoning, they may well be able to, but
Right.
that's probably not gonna have much of an impact legally on the
So-
board. But what I'm trying to get,
Now I could report back to them and tell them what the
well,
condition of
they
this
need to
is.
communicate with the board directly,
Okay,
in a letter, on their own stationery, or counsel to communicate with the board to, just to express more specific objections than a generalized objection if they
Yeah.
just don't like it, and they're gonna do the same thing.
well, you know, the letter goes out and then there was changed 3 times the date for this, or twice.
Yeah, that's
so-
been a problem, and we appreciate
So, you
the
know,
inconvenience.
I was able to catch on
Yeah.
and they sent me in.
Yeah, but if you could just relate to them that, would they communicate with the board in writing?
Okay, so
or-
what's their timeline for that?
This will be adjourned for a month now, so
All right.
it'll be July 7th, the next hearing.
Okay, so I'll take it from there.
Plenty of time, yeah.
Thanks.
Thank you.
Is there any further comment?
So we'll adjourn
Well,
for
I
all
think that,
purposes,
based
or?
upon
Based upon
Carl's
the,
statement that the matter should be adjourned for all purposes and the opportunity for these people to make a more specific and formal objection to the proposal. Unless, there may be other reasons for adjourning it, but that's at least one that I can think of.
It's a start, but
Yes.
with the
Okay. So Bailey, we'd like to adjourn this for all purposes?
July 7th, you said?
Yeah.
Okay.
I'll make a motion at the request, I will make a motion to approve the request of the applicant to adjourn the Cowles Associates to the, for all purposes, to the July 7th meeting.
But if you could tell your employer that it's important that they make some formal communication with to the board before that.
I'm sure they will.
Thank you very much.
Okay, I'll second that.
All in favor?
Aye.
Aye. The South Lane properties at 104 Gin Lane.
Okay, for the applicant Gilbert G. Flanagan, 21 South Main Street, Southampton, I have an affidavit of posting and an affidavit of mailing. That's just for the second round, not the first round. As you probably know, and as you've seen before, this is an application to divide this property at 104 Gin Lane into two conforming lots, each of which will contain at least 120,000 square feet. We have been through some discussions with the board about this, including, most importantly, the straightening of the division line between the two lots as they lead up to Gin Lane. So that's the map that you have before you, which was prepared April 16th, 2013. Now, at the last work session, I was provided with a copy of a staff memo from Nelson Pope and Voorhees, and I just touch on a couple of the items in that. First of all, I'd like to start off by saying that the motivation for my client to do this is for estate planning purposes. There's no intention at the moment to do anything physical to the property, but it's being driven by estate planning concerns. That having been said, as we noted at the last meeting, the work session, I believe, there's a driveway which starts out on Lot 2 and winds up servicing Lot 1. And I think certainly for so long as these lots are controlled by the same entity, there would be no reason to change that. And what we would propose to do, so as to make everyone comfortable, would be, as a condition of final approval, to define an actual driveway easement. Down the road, it may be that it would make sense to provide a separate access for Lot number 1 and Lot number 2. But as I had a lengthy discussion with my client this morning, and if it turns out that he sold Lot 2 to somebody he was friendly with, he might want to continue the easement. And if not, he obviously has more than enough street frontage to create a separate access. So I think what we'd like to do then would be to, as I say, the intent is not to do anything physical at all for the foreseeable future. But we would create a driveway easement that would deal with that situation, so that there would be something that could be filed when the map is filed, so as to avoid that, any question about that. And we would provide, as I say, a legal description for that.
Earlier.
Yeah, at work session. Can we get a copy of that map for a second? I assume you guys have, right? I think it's in the file. I don't think it's this one.
So that would be a legal description for what, a driveway easement
Yes.
to the interior lot?
Yeah, let's be specific. It would be a driveway easement over Lot 2 for the benefit of Lot 1.
That's 104 Gin Lane.
Yeah. So they're talking about.
Once the easement is recorded, wouldn't it require the purchaser of the lot to accept the easement?
Yeah, unless the two agreed as a condition of the sale to do away with it. And I think that would probably happen if he sold to somebody who was totally a third party. That would probably be a condition of the sale, that would be extinguished and we would set up another driveway access. So we see no reason, as I say, that from what I understand, this will probably remain the same for as long as these people own this property. So it's not unlike the conditions you impose when you divide a lot and you have an accessory structure on a lot without a main structure. It's the same concept. So the goal here is not physically to change anything at the moment. So I think we can handle it that way.
They got two lots.
There were some additional informational notes that were contained in Nelson Pope's memo, and we would intend to provide those, including sanitary systems, location of adjoining buildings, and some of the other technical information. So we would plan to do that before you close the hearing.
Bill, I think Kathy's hope and the example that you raised is that if there's accessory structures, that they're required to be removed in the event that the property changes hands. And it would seem to me a better way to do it would be to have that kind of a condition attached to this subdivision requiring the driveway to be relocated in the event that it changes hands. Would your client be amenable to that?
I guess he might, except for the fact, as I say, if he sold to a really close friend,
Mhm.
and the friend said, gee, and they'd be agree to leave it,
Mhm.
I think that.
And excuse me, Gil, there is another, this is an accessory structure, right? This says
No, no,
two-story
no.
house and
Yeah,
garage.
absolutely, there are no variances being requested.
So
This is
so
a
there'll be
dwelling.
another house on the other lot.
I'm sorry?
There'll be another residence on
Yeah,
the
there
other
could
lot
be.
as soon as it gets divided. Well,
Right.
this says two-story house and garage.
Right, so there
So
is
do we
a
have a
residence.
CO? Is there two COs
Yeah,
for
there's
two
a CO.
residences?
Yeah, there's a CO for this, there's a CO for everything, and that part of what you requested is
Right.
we provide. There is a fairly current CO.
So
for
once
everything.
it was divided, you'd have a residence with a tennis court, so
Right.
it wouldn't just be an accessory structure
No, no.
without a residence.
No, I didn't mean to suggest, I said it's analogous, the driveway situation is analogous. No, this wouldn't require any of the normal relief that you give for leaving an accessory structure without a main structure.
Right, right, right.
In fact, now that you pointed that out, we designed this, if you note, the lot width where this building is 200 feet, which is the lot width required for where a residence has to be located. So we were very careful to design this so as to conform with all zoning requirements. So I think the answer to your question, Mr. Chairman, is we'd like to be flexible. And I talked to my client, he said, as a practical matter, if I sold to some total third party, I want him to have his own driveway, but if it's my best friend, then why shouldn't we leave things physically the way they are? It's not all that uncommon to have easement servicing property either. There's clearly legal frontage to handle the situation. So that's what I would hope we could do with that. I have nothing
So is
further.
it your wish that we schedule this for
We
a
have to-
public hearing?
This is the
actually
public
is
hearing.
This is the public
hearing.
Oh,
And I
okay.
understand there may be some comment from someone else, so I'll reserve the right to add anything after that happens.
Do we have any comment from the public?
Yes, I'm Linda Riley, 235 Hampton Road, Southampton, New York. I represent Josh Harris and 154 Gin Lane LLC. That's the property that abuts this property. It's adjacent to it directly to the east. So the next door neighbor, essentially. And he is deeply concerned about several things. Some of it is, as you called it on the last application, generalized objections. I understand this is being done at this point in time for estate planning purposes, but the fact of the matter is, it's being done so that it can accommodate, two fully developed lots. So what you're looking at is, you have to assume that it's going to be fully built out at the end of the day, because it seems like everything sooner or later is here. And there may be some things, I'm not sure yet from looking at the record, but there may be some things that require some relief, possibly, I don't know. Don't know what the gross floor area is of the main house. I'm not sure if that would require relief when the lot is reduced in size, since it's based on a formula of lot size. My client is concerned about really the general impacts of this increased density. You have to figure that sooner or later a much larger house is going to be built on that new lot. And it's really right next door to him. In fact, the existing house violates the side yard setbacks. It couldn't be built today in its current location. I concede that it's lawfully grandfathered, but if that were somehow added on to or the footprint is reused, it's going to have an impact. It's only 25 feet from his side property line. The tennis court, the same thing. Both of these lots are eventually going to be fully developed, perhaps with 2 tennis courts, perhaps with 2 swimming pools, and all the noise and the light and the activity that comes with it. The tennis court is violative of the side yard setbacks at the moment, and also dune setbacks. We don't know where the crest of the dune is right now, but maybe someone should take a look at really requiring some, relocation of some of the existing accessory structures to reduce the, possible or mitigate against some of the impacts of this increased development later down the road. He is also concerned about using that existing driveway. There are 2 driveways on this lot now, both of which are going to be on the lot that's, closest to my client. One of those driveways is right up along the side property line, and were that to be used as a completely independent driveway, it too would have an impact on the use and enjoyment of his lot. I haven't had has a long-form EAF been turned in here? That's in the form of a question. I haven't been able to determine yet where the secret review stands.
Well,
They were gonna try to get a
decision's been made, it's just that the technical part.
The property line's right.
Is it a long-form EAF?
To put this on here or just put it
It's a short form.
It's a short-form EAF.
The new short form.
I mean, the board may want to consider requiring a full EAF here. It's obviously a very environmentally sensitive lot. It's on the ocean. It has, a lot of natural features, and it's been undeveloped for a long time. And I would suggest that you think about doing that. I haven't had a chance yet to see the Nelson Pope and Voorhees memo. I'd appreciate having a chance to do that. So if you could adjourn it till next month, we would appreciate that. And if we could consider some of the points that I've raised.
Response?
I'd just like to say a couple of things.
So what happens?
I think a lot of the objections are generalized objections.
Bill, could you speak to the microphone?
Yeah. I think a lot of the objections are generalized objections. The property, if the property were developed in a more substantial fashion, particularly the easterly lot next to Linda's clients, obviously that garage apartment, which is a separate dwelling unit, would have to be discontinued because you can't have 2 residences on one lot. And as you can see from the map that was submitted, there's a substantial as-of-right building envelope that meets dune setback, yard setback, and all of the other zoning requirements. So, in a way, developing this lot would actually, I would think, could result in a benefit to the neighbor, because you would then have a house up in here as opposed to a house down in there. So that may be something you should consider. I will check about the GFA question. I don't think there's any problem given the size of the larger parcel. I can certainly look into that. Nothing related to this application deals with the existing accessory structures, of which have been there for many, many years. We're not proposing to go closer to the crest of the dunes or any coastal erosion lines or any of that. I would submit that really isn't relevant to the question of a subdivision, since the subdivision really is having no impact on those structures. I think that given the fact that this totally is a conforming situation, unlike the first case, it didn't require any relief. It should be afforded a fairly positive view by this board. And I would submit that because we're not doing anything environmentally significant in the terms of the dunes, any other environmental features, that the short form EAF would be sufficient. I know in other cases where you've looked at subdivisions where there have been no physical changes, you've agreed to use a short form EAF, and I think in this case that would be appropriate. But since I gather there's some additional information that you may want, I would not have any objection to putting this over for all purposes for a month.
Gil, could you, when you're checking the FAR for the main big house, could you just let us know what size of a main house could be built on the other lot?
Sure,
The
maximum
smaller lot?
GFA, sure.
Just so we can see that, what we're dealing with in the future, although the granting of this doesn't guarantee anything either way, so.
Okay. can do that.
Thanks.
Thank you.
Any further comment? I have a motion at the request of the applicant.
I will,
No, motion to approve the request of the neighbor who was asked for the adjournment.
Okay.
The applicant simply said he had no objection to it.
I will make a motion to approve the request of Linda Riley representing Joshua Harris to adjourn for all purposes the South Lane Property LLC to the July 7th meeting.
I'll second that.
All in favor?
Aye.
Aye. Mitchell Family Real Estate, 180 Great Plains Road.
Need to announce the public hearing.
Which is a public hearing.
Again, for the applicant, Gilbert G. Flanagan, 21 South Main Street, Southampton, I have an affidavit of posting and an affidavit of mailing. Okay, this is an application that you, as I mentioned before, that you've seen a number of years ago, and we're back here basically to redo that subdivision with a very slight alteration in the division line between the two lots. When we talked about this the last time, you felt that since this had been reviewed so many times, we could move right to a consideration of a final application. And we therefore have labeled that accordingly. There's one technical thing I'll point out, which I believe your file should show. For some reason or other, an earlier version of the site plan we submitted had a label that this pool house was to be removed. That was, I don't know why that was put on there. It was an error. So now the pool house obviously conforms in all respects, and there would be no reason to remove it. So that note was taken off. Again, both of these lots, well, in this case, they're substantially oversized. As you can see, Lot 1 is over 191,000 square feet, and Lot 2 is over 155,000 square feet. So they are more than conforming in all respects. This does have a situation where there would be accessory structures on a lot without a main structure, and we would propose to do the same thing that we've done in other cases where those structures could remain so long as there's a commonality of beneficial interest between the two lots. So I don't know that I need to say too much more about this. It's been reviewed quite a bit, and I'll shut up.
Is there any public comment?
Who was the woman who walked out?
Linda Riley, attorney,
Wouldn't mind if we close the
Representing
public
the-
hearing. Nobody has.
She was up
representing the neighbor.
right here, right here. No, okay.
So we can close the public hearing, Bo?
Yeah.
Bo?
Yeah, I'm thinking.
Oh, okay.
Right.
Finished with Mitchell.
Not yet. Almost.
Next.
No, well, we're on it now.
Notwithstanding Scott's good counsel, I would, pending just my ability to confer with Nelson Pope and Voorhees, ask that you keep it open for one more hearing, one more meeting to July 7th. So adjourn for all purposes to July 7th.
Okay. Does Scott have something
There
now?
was a memo, there was a memo of April 16th from Nelson Pope and Voorhees, and we've complied with everything that was on it.
Yeah,
So
thank you. Yep.
perhaps we could adjourn it with a possibility of a
Yep.
resolution then. I would be happy with that.
So make a motion that, to approve the request of the applicant to,
I approve the request of council to adjourn for.
okay,
all
to approve
purposes.
the request of council to adjourn for all purposes and a possible decision, I guess, of the Mitchell Family Real Estate, 180 Great Plains Road to the July 7th meeting.
I'll second that.
All in favor?
Aye.
Aye. All right, moving into the subdivision review section of the meeting. OIA Associates applicant requested that the board, no, actually the board offered to send a letter to the Southampton Village trustees requesting action on the board, on the applicant's request for a review of the park fee that had been determined. And counsel, you have drafted
I
such
drafted
a
a letter,
letter?
and that will be sent out, hand-delivered to the trustees tomorrow morning. So that would be then adjourned for all purposes to July 7.
Automatically or by motion?
By motion of the app. Bailey, you want to make a motion?
I will make a motion to approve the request of the applicant to adjourn for all purposes of the RAI Associates to the July 7th meeting.
I'll second that.
All in favor?
Aye.
In the second item, our John Punnett, 220 Hampton Road, a decision has been rendered by
Resolution is
council.
in the file approving the sketch plan.
So we just need a motion to vote
Approve
on
the decision, approve the resolution as
approve the
drafted.
resolution.
I will make a motion to approve the resolution sketch plan in the application of John Punnett.
I'll second that.
All in favor?
Aye.
Is there an extra copy of that, or could I get it tomorrow, or do you have an extra
I
copy?
think there might be one in the file, Pam.
Let's see what I got.
There should be an extra.
If not, I
copy.
can give you mine, then, Gil, and I can get an
Each
extra.
board member has it.
Scott, could you pass that over? Thank you.
You could,
Thank you.
thanks a lot, appreciate it, okay.
I should do this.
550 and 554 Hill Street has been adjourned to the August 4th meeting.
I think that may, excuse me, I think that may have been a mistake. We requested it to be put off to the July meeting, June work session for the July meeting. So maybe that, I have my letter of May 23rd.
Okay.
So if you guys could do that, that's what we requested.
I will make a motion to approve the request of the applicant to revise the adjourn date on 550, 554 Hill Street to July 7th meeting in lieu of the August 4th meeting.
Second?
Second.
All in favor?
Aye.
Aye.
We would adjourn Pep 2 Holdings at the request of the applicant, both the site plan application and the subdivision. Next item, Harkonnen and Atreides, which is pending decision.
Mr. Chairman, in reviewing the file, I noticed a memo from Nelson Pope and Voorhees dated January 8th, and in reviewing, comparing that memo and the items identified therein with the map hadn't changed since October 13th. So there's some discrepancy between the status of those comments in the memo and the map. And based upon that, I did not prepare a decision until we get some clarification on this. The request was to identify street trees along First Neck Lane, identify a common driveway access, or a proposed driveway access for the new lot. There was one other item. I've also noticed that I think that there were several parts of the map was unidentified also. It just says subdivision map, it doesn't say sketch plan. I know that the tennis court was under construction, it may be completed, but that doesn't show. And the driveway, there is apparently a common easement with the neighbor to the south. And I presume that there's no point in having two driveways go that length, parallel to each other. But the map doesn't really fairly show where that driveway is within the easement. So I think that ought to be, addressed also. So based upon that, did not prepare a decision, and I think that if you have any comment to that, Bailey, but pending any comment that you do have, then I'm asking that the matter be adjourned for all purposes to July 7.
Has the applicant been advised of the issues that need to be clarified?
Only now.
Only now.
But I'll confer with Scott or Kathy in the meantime, and Mr. Bennett, I understand, is out of town this week. Indisposed in another country with a laborious task. But
Well, they all, all the documents should match up.
they need to be updated, I think, so we'll confer with John on that. And
And we'll get
meantime.
something from Nelson and Pope that
It's in the
itemizes
file.
it? Or
It's in
already
the
is
file, but I'll confer with Kathy, and they may want to revise a couple of items on that.
So Bailey, would you like to adjourn this for all purposes? I will make a motion to approve the request of the applicant to adjourn for all purposes the Harkinen and Treaties, 408 First Neck Lane, to the July 7th meeting.
I'll second that.
All in favor?
Aye.
Aye.
Next application is Damon Metzakappa, 430 and 420 Halsey Neck Lane and 139 Cooper's Neck Lane. Is there a representative from the applicant here? Thank you.
Hi there, I'm Laurie Wiltshire with Land Planning Services, and I'm with my associate Susan Brierley, who was intrinsic in putting the application together. So if we have any questions for us, please let us know.
One of the items that came up in the work session was just some consideration given to the fact that this is a large chunk of farmland, and the village master plan suggests that some consideration be given to maintaining open space and preserving farmland.
I would like to speak to that. The applicant has no intention of developing these lots at this time. It will continue as farmland. It's estate planning only. There's many children in the background, and it's just to protect the value of the lots as they shall be once they're divided.
The issue is that if it's estate planning, that could happen tomorrow. This is a planning board looking into the future, so I think the board is inclined to probably ask for a cluster type of proposal on this application.
It doesn't really make a lot of sense given the neighborhood. I mean, these are all large lots. I mean, even the most recent subdivision you did right next door for, literally, which is still being farmed, for Melinda Hackett. That was done in 2007. Those lots are the same size as what we're proposing, and on the same street. The long rectangular lots that lead away from. So I think we'd be inclined to not want to have clustered lots in this area. It's not farmland, it's the village. I mean, these are home sites. It happens to be farmed. But it is zoned R120, and what we're proposing meets that zone. I believe the comp plan is a recommendation. I think that small house lots in this neighborhood would do a disservice to the value of other properties surrounding it. And that, I think, would probably come up as an objection at a public hearing. I don't think you want to see half-acre lots in a neighborhood that's all 3-acre lots. It doesn't make any sense to me as a planner.
Nobody's suggesting half-acre lots.
I don't know what you would be suggesting in terms of clustering.
The applicant to make a proposal.
I don't think my clients would be terribly interested in that. I think they're more interested in having the lots the
They
size.
may not be interested, but the board is probably going to ask for that. It's not an official request now, but you need to report to them that that's what's under consideration in the mind of the board.
It's also not the type of a cluster plan where you can put them all together, because we've got L-shaped property going on here. It would be one lot is over here and one lot's over here. So it would be an awkward cluster. We can discuss it with our client. I mean, is it something that's mandatory? The way I read this memo, it seemed that you would have to get the town board's permission to enforce a clustered plan in this area.
Village board would have to ultimately approve it.
I mean, the village board, yeah.
They would have to ultimately approve it.
Ultimately approve it, right. So I guess I'm kind of inclined to know where the board is headed with this,
Well, it's
because
something we're charged to consider. And to consider it, we'd like to have some, I mean, you're beginning to discuss it now in terms of why it's not feasible, what a possible plan could be for consideration to offer a cluster, why that works or doesn't work. I mean, those are the things that we need to look at in terms of evaluating the overall
we
application.
can certainly provide that information for you. It's not a problem.
Is this for the undersized lots? The
No.
undersized?
No. These are,
5 of them, 6.
yeah, but I think this is they're all conforming lots. All conforming.
They are all conforming,
3 acres.
I think they exceed the conformancy, don't they?
slightly. So you just want a discussion, or are we supposed to bring you
No,
a
the plan.
plan? How do you want that presented?
Scott?
Could we have like a planning meeting and discuss it, like in a round table discussion, you know, with the planners meeting with the applicant's planners? You know,
We could at the work session, right?
Yeah.
When is the next work session?
The last Monday
Last Monday
in June.
In June.
June 30th.
And in the meantime, we can broach the subject with our client. When he read that in the memo, he was not pleased, but we can go back to him with it. But I don't know what you're actually proposing in terms
Not
of.
proposing anything, we're asking the applicant to consider it, and it's up to the applicant to provide a design that would be acceptable to the board, maybe several designs. But the intent here is to try and preserve some open space, not just necessarily for farming. We realize that, and it's already been discussed, that nobody's going to drive a tractor from Watermill to, this location to farm this land in the future. But again, it's an attempt to try and preserve some open space. The applicant can say no to that, or they can say they'd like to consider that and make a contribution to the community. We don't know, but the question is being raised, and that is the request to the applicant.
Okay, well, we will take a look at
Yeah,
that and
we'd
sit down with you
appreciate
on the 30th.
Yeah, we'd
Are there any
appreciate it.
other issues in here that, everything else seems perfectly understandable to us, the drainage pipes, the 25-foot wide flags.
What was the, do you know anything about the drainage?
I don't actually. We sent this off to our client, and he did not respond on that point, but we will find out more about
Board
it.
doesn't really have knowledge of what that is or
Did he
where
get
it
back to you?
goes or how
Okay.
it was established.
Susan Brierly. He is not aware of the drainage pipes. He was very surprised when I informed him of them. He will be taking steps to have them removed.
Do you know
Along
how they
with the
got there?
rock.
Does anybody know how they got there?
The neighbor installed them. He actually approached our client some time ago asking to purchase that portion of the property from him, and he was turned down.
So you think they were
Just put in because he
Imposed.
wanted to.
improperly?
Yes, I think so.
It appears from the map that there's a swale there, and the soil is quite moist, and I think that it must be coming off of the neighbor's property and laying in that low area, and those pipes are facilitating that. Anyhow, the one question I do have, well, I suppose we shouldn't revise, or I guess we could go ahead and revise the maps based on the points in here. My one question is, it's suggested that contours be on the map, but this is really flat property. Do we really need contours on the survey?
Well, it would help to see which, even if you gave corner elevations.
Corner elevations would, make sense.
We all know that the property is flat,
Yeah.
but somebody in the Suffolk County Center may not.
Okay, so you think the corner elevation would be sufficient?
Yeah, if it's that flat, you wouldn't see any difference
You
between.
really wouldn't, that's the problem. Okay, so the question then is, given the few points on here that we need to address on this map, should we go ahead and have that done prior to the meeting on the 30th?
Yeah, I think it would help because then you have a more realistic endpoint to work from.
Okay, very good. Is there anything else?
It's not to amend that map, it's to show an alternative.
Well, we would do both, because this map can't be approved as it is because it doesn't meet code in a
Well,
couple of ways.
you'd make whatever technical adjustments to that.
Right,
present map, but
right.
Again, the other map is not to amend that, it's just to give the board a proposal as to what might possibly be created.
I think we'd rather sit with the board at the work session on the 30th to talk about what they think might work,
That's
and then we
perfectly
can
fine.
take that back to our client rather than paying for maps that
Yep,
aren't what you're thinking.
very good.
Okay. All right, so if there's nothing else, have a good evening.
Would you like to adjourn this till next month? Yes, you would?
Yes,
Okay. I will make a motion to approve the request of the applicant to adjourn for all purposes the Damon Mezzacappa to the July 7th
Your turn.
6:30.
meeting.
To the
Planner.
work-
Well, it'll automatically be on the work session then, if we adjourn it to the meeting,
Correct.
right?
Correct.
It automatically goes on
Correct.
to the work session. So the
Okay.
July 7th meeting?
That's what I thought.
You have a
Second.
All in favor?
Aye.
Aye.
It's very funny.
Okay, in the site plan review, we have Bod,
Yeah, nothing there.
has got nothing new.
I don't know why they still have it on, but I'll
Right.
check.
Okay.
The Jonky property, the same thing, sort of exists with this. I have several questions with regard to this and the maps that are shown. There's no updated map. There's no updated map showing the easement where it terminates, where the driveway is. So pending the ability to confer with John, there's no way that I can draft a resolution. Also, the survey that's proposed is deficient and it lacks several dimensions that should be included, one of which is the dimension of the fee access at Hill Street, and then also the width of that at the south end of the southeast corner of the lot. But if this is going to be an amendment to a subdivision map, we need more of a detailed map than what's in the file. So Gil, I don't know whether that was you're handling that or John is.
No, actually, John, as you know, I represent the people who
Yeah, you represent.
have the house.
I just don't know how you're coordinating who's going to change the map. And
Well, that's really not my bailiwick, but just to let you know, the proposal is not to change the subdivision, it's to change the length of a driveway easement within the flagpole strip of 483 Hill Street. So it,
well, wasn't that a covenant that was part of the subdivision?
yeah, it was by way of history.
I mean, I use that term very broadly.
Yeah, no,
We're
I know.
not changing the dimensions of it, but we're changing a part of what was approved for the subdivision.
Yeah, you are. Originally, there was only a 60-foot easement, then it went all the
Right.
way back, and now we're asking to shrink it.
Right.
But yeah, it's a change in a part of the design.
Right, and
Yeah,
that should be reflected in
I agree.
a presently dated map, and that's just not in the file.
All right, that's something I'll
Yeah,
have to get
okay.
from John, because.
All right, well, do you want me, I'll check with him then and ask him to confer with you then as necessary.
Great, thank you, that'd
Thank
be
you.
fine.
Do we hear another adjournment request until July 7th?
Yes, can I just confirm the last memo was February 24th, 2014, and those are the comments that hadn't been yet addressed?
Scott, I don't have the file in front of me. Pam?
What do you want?
Memo last dated Nelson Pope and Bory's memo. I think, I looked at, my comments are in
2057,
addition
yeah.
to that memo, Bailey, so it's both.
February 24th?
Yes.
Okay.
Yeah.
Okay. So I will make a motion to approve the request of the applicant to adjourn for all purposes.
Thank
the
you.
Elizabeth Janke until the July 7th meeting.
Second that?
All in favor?
Aye.
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 Crease Properties, 16 Windmill Lane.
I think we're just waiting on stuff from them.
I think we're waiting on stuff from them, yeah.
You finished with Yankee?
Yep.
This is the Time and Again building, right?
Yes.
Yes.
So we requested revisions in a full year, yeah.
And there was-
Was Rooney doing that one too?
Yeah, I thought so.
Yes, he is.
But I think we're still waiting for floor plans and a full EAF, right? And Scott, you didn't get those?
No.
Okay.
They probably should have included that request for adjournment
Yeah.
with the other ones.
This one's okay.
Yeah.
That was in the paper.
This one's been adjourned, we're on this one now.
So in view of the fact that the applicant isn't present and we haven't received any information, I have a motion to adjourn this application at the request of the applicant until the next meeting.
So moved.
A second?
Second.
All in favor?
Aye.
Aye.
Donna Oplinger, 106 Prospect Street. Kathy had done a little bit of work on this. Scott, have you got any further information about this?
No, we're still waiting on the building department records regarding the shared parking.
So really just waiting information and nothing further to be done at this time.
Yeah.
That's a little dinky place over there.
Mhm.
So can we,
I will make a motion to approve the request of the applicant to adjourn for all purposes the Donna Oplinger until July 7th, 2014.
I'll second that.
all in favor?
Aye.
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 and the Real Estate Organization Belgium LLC, 477 First Neck Lane. A new site plan application with a lot line modification.
This is empty.
Because everything else has been adjourned. Is that you, Bailey?
Yes, it is. Essentially, what they're requesting approval for.
Can you go to the microphone, please?
And identify again.
Bailey Larkin with Bennett and Reed. Essentially, what they're asking for is to transfer an existing driveway from one parcel to another. It's a small, narrow strip of land. It's a non-conforming lot, and it would be transferred from the property, I guess it's to the east, to this property. The driveway is existing. It's accessing a proposed home. There's currently a home on that lot that's being demolished and a new home built in its place. The neighboring property owner obviously has no objection to it. They're transferring the lot over to this owner, so that's basically it. If you have
Is the
questions.
driveway closer to the property line or farther away from the
It's an existing driveway, actually. The driveway has been existing, and it was on someone else's lot, actually, all this time.
That's the one where the old thing went across the wetlands.
So the idea is to purchase the property that the driveway is on.
Exactly.
Chairman, can I ask a question?
Sure.
Bailey? That stone driveway on a ZBA drawing had shown it to be removed, you know?
It's
That's
to,
all.
it's to remain, I believe. Yeah, and I think it's shown on the map we had submitted with this application. The lot, the subject lot that's acquiring it is a flag lot, but they don't have a driveway on it, so he's gonna keep the driveway here on this parcel that he's gonna acquire.
Okay.
Instead of building a new one.
Do we require further input from NPV, Bo, or should we schedule this for public hearing?
Aldo wants you.
At the last work session, there was some discussion, raised the issue of possibly doing some sort of drainage, since the properties direct itself to Cooper. So when I requested the board, I went out to take a look at it last week, and the area is heavily vegetated, and after looking at it and picking up a few ticks, I decided that a structure would not be appropriate there. I think if anything, there should be a note on the map saying that the existing vegetation should stay in place and not disturb, because that's acting as a good filter and protecting that creek. So I just wanted to report that back to the board. Thank you.
I would say adjourn for all purposes, and it's not a particularly complex or involved application, but just for the sake of good order.
Is that okay with you, Billy?
Yes, that's fine.
I will make a motion to approve the request of the applicant on the Real Estate Organization Belgium to adjourn for all purposes to the July 7th meeting.
I'll second that.
All in favor?
Aye.
Can't we do a public meeting on it if there's nothing else to be done?
I just asked that to Bo, and he suggested we adjourn.
I'm sorry, I didn't hear you.
That concludes all of the applications. We're now considering approval of the previous minutes from the previous meetings. I haven't actually read the May 27th, so we can approve the April 28th, 214 minutes if there are no objections or comments. May I have a motion then?
I'll make a motion that we accept the minutes of April 28th, 2014.
Second?
Have we seen the site
Second
plan?
it.
All in favor?
Aye.
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 The next meeting of the village board will be a work session on June 30th, followed by the public hearing on July 7th. Being no further business to discuss, may I have a motion to end the meeting?
I'll make the motion to close.
Second?
I'll second.
All in favor?
Oh, you're falling asleep. Aye.